So we will now open the public hearing. And it is 5:57. So we will open a continued public hearing will be held on Thursday, September 26, 2024 at 10 West State Street, Granby, Mass. To consider a gravel permit application by LJ Development LLC, applicant and owners James and Kathy A. Slate, ET.AL, 44 Mercier Drive, Belchertown, Mass. To remove earth materials from property located on Tromke Ave as per the zoning bylaw, section 5, sorry. Special use regulations and performance standards 5.8 earth removal of the town of Granby. All right. So, is the applicant here? Yes.
We are.
Thank you. So I think to open up this hearing, we would first like to hear from the applicant. If that's okay.
Sure. Okay, good evening. Again, for the record, my name is Damian Berthume. I represent the applicant in connection with the gravel permit application that you just mentioned. I'm not sure if this information has been circulated largely, but prior to the last scheduled meeting, my client's engineer, Mr. Frederick, who's with me tonight, did submit a letter to the board indicating that we were looking to reduce the scope of the project to about 25% of what we had originally asked for. So the original ask was 40,000 cubic yards. We did submit a request asking that the scope of the project be reduced to 10,000 cubic yards per day, which, according to Mr. Frederick's calculations, should be on the letter that you have, would result in about 2 to 3 truck trips per day to the site. At our last meeting, we certainly heard opposition from residents and concerns about traffic and congestion. We tried to listen to that and present something that we thought would be respectful of the community and to reduce those number of trucks. Based upon the reduced truck traffic and the fact that the expectation is that the trucks would be driver loaded so that there's not a lot of additional traffic into and out of the site. It seems that a traffic study here, although there have been requests for that, I think not from the board, but from some of the members of the public that have been here, is really unnecessary. Because I would suggest that 2 to 3 trucks in and out of the site is such a de minimis addition to any traffic that doesn't reasonably justify a full study for that number of trips. We also, I think the board did request information concerning sound. And so we do have an acoustical study that I will be happy to share with the board. I apologize. We thought that this had previously been sent to the board, and due to some miscommunication among us, it was not submitted. So if I may, through the chair, ask this in.
Thank you.
So we had this report prepared by Cross Spectrum Acoustics. They took the noise parameters that are included within the Town of Granby bylaws, and you'll see those are identified on page 2. They also identified the type of equipment in table 2 on page 3 that would be used at this site. And based upon the analysis that they performed, you can see in the paragraph just below table 2, their ultimate finding is that operations at the Tromke Avenue site will meet the Town of Granby noise level requirements. So our suggestion would be that we've demonstrated that noise would not be a concern here. There are some suggestions, I guess I'll call them, that the engineer included on page 4 of the report. We'd certainly be amenable to those if the board were inclined to grant our application. Although I would suggest that based upon the scope of the project that we're talking about, with only 2 or 3 trips per day, we're not talking about a situation where trucks are going to be queued along a road waiting to be loaded. So that condition may not be necessary.
And I'm sorry, I did, excuse me for one moment. I do want to let the audience know that there is someone else filming tonight. So I apologize. I should have started off with that in the meeting. So besides GCAM, there is another gentleman filming, just so everyone knows. Sorry about that.
That's okay. At the last meeting, we did talk about some title concerns with respect to Tromke Ave. And what I would suggest is that Tromke Ave is a private way. There were concerns expressed that a portion of the gravel area, which is physically located on the ground, that is the physically traveled way as it presently stands, is located outside of the layout of Tromke Ave as shown on the plan. We would certainly be amenable to a condition that we have that gravel way surveyed and that we take steps to move the gravel way within Tromke Ave if the board were concerned about that as well. I think that should alleviate any concern regarding title issues in that respect. I think that we, in our presentation last time, identified the basis for which we felt that we satisfied all the criteria in the zoning bylaw for the granting of this special permit. And so I would at this point end my presentation and reserve the right for either myself or our engineer to address any other concerns that are brought up tonight.
Thank you.
Thank you.
This is the cross spectrum. So Attorney Costa, I know Dave is still reading over the report that was given to us for noise study or acoustics. As we look at 6.27, there was 11 criteria that have to be met in order for us to grant the gravel permit. And when I look at number 5, it says the proposed use shall comply with the environmental performance standards specified in section 5.2 of this bylaw. So I know one of the concerns that the people had, as do I, and I don't feel like I have enough information to cross or check this box off, is whether or not there's going to be particulate matter in the air. So I would need a particulate matter study done in order to check that box to say whether or not they have met that standard. So I don't know how the other board members are feeling, but that's one of the ones that I don't have enough data for.
I would tend to agree. It is one that was asked for in the criteria.
I don't think it's unreasonable, but I would ask that we have other gravel pits in town, and we haven't done a study for that such. So is that something we should be then looking at for all gravel pits?
Well, according to the criteria, I think the other ones were, and correct me if I'm wrong, but weren't they they've been in business for a long time. So we didn't grant the original one, right?
But
This board did
but
it.
we renew it every year though.
Based on what the Conservation Commission has told us. So the Conservation Commission goes in there, they inspect it, they say, yep, they're operating within their means. And then we grant it based off the compliance with the Conservation Commission.
No, but I understand that. I'm just,
Yeah.
if we're asking for one, should we be asking for all, if we're concerned with one having, the particular matter into the air, we should be addressing other ones as well.
And I don't know if the other ones are by a brook and everything else. I don't know if they are. But I can really only speak to this one. This one is.
No, I'm saying I agree
Yeah.
with you in regards to the study, but I'm also saying that that would be something to look at for the future as well.
And then I did have on here that I was requesting more information for number 7, which was the traffic analysis that I was looking for. Just because I didn't have enough information, but I do know you guys said that you were decreasing the cubic yards from 40,000 to 10,000. So instead of 18 trucks each day, it's 2 to 3. So I don't know. It's the traffic analysis.
Incorrect.
I know. We have 4 other,
Incorrect numbers.
excuse me, we're talking for a moment, but we have 4 other gravel pits that are operating on that road right now. And I think they're also 10,000 cubic yards that they're taking out that we have granted yes to. Yes, absolutely. We have enough here.
Thank you. Just so I can be heard. I guess I would caution the board. There we go. I guess I would caution the board to just be focused on the application that's before you. I don't disagree that, and I recommend to boards I represent that you be consistent in your application of your bylaws. So certainly if there are other gravel pits that are operating in town, if those pits come back before you for renewals or new pits come before you for special permits, you should consider what you've done in other similar circumstances. Now, every gravel pit may not be the same. You may have some that are surrounded by residents. You may have others that are quite a distance from the nearest residence. So you do have to evaluate each case, each application that comes before you on its own merits, but there is something to be said for being consistent with respect to uses within the community. On the issue of traffic, and again, that rule applies to traffic as well. You know, there are different types of impacts that result from traffic in my experience. I'm certainly not a traffic consultant, but I've been involved in enough projects where traffic consultants have been employed by boards like yours to provide peer reviews, and where boards like yours have requested that applicants provide either full traffic studies, which can be 150 pages in length and can take weeks to perform, or traffic assessments, which can be a few pages in length and can be much more brief and to the point. Obviously, not as comprehensive in terms of what gets studied, but they can also be turned around much more quickly. And they perform, traffic consultants do both a qualitative analysis, looking at the type of traffic that might be generated by a project, because obviously, a new development of single family homes is likely going to generate mostly traffic from passenger vehicles, the occasional pickup truck. That's going to be different, for example, from traffic that might be generated by a gravel pit, or traffic that might be generated by a landscaping operation, where you're going to have more commercial vehicles coming and going on a regular basis. So there's that qualitative component. And then there's the quantitative component, which is how many vehicle trips are we talking about coming into and exiting the site on an hour-to-hour, day-to-day basis. So I leave it to you to decide whether that's appropriate in this case. That's beyond my pay grade, and that's why you get the big bucks. But it's up to you to decide whether you think you need a full-blown traffic study for a project like this, comparing what was proposed originally to what's being proposed now, which is reduced in size. or whether you feel you need a traffic analysis or assessment, which is something lesser in scope, or whether you're comfortable without either. That's a decision for the board to make, but you certainly have that within your purview. You've got 11 criteria for the issuance of a special permit. You have to make affirmative findings with respect to each of those criteria that each is satisfied. And if you feel that something is prohibiting you, the lack of information is prohibiting you from making a finding, I'm sure the applicant would rather provide you the information you need and give you an opportunity to review it than to get denied for failure to comply with one of those standards.
Thank you. So with that
I'm fine if you're looking to do a traffic study. Just
assessment,
Assessment. It just provides the select board with information that we're requiring.
Could you please use the microphones that are provided? Because now there is a snap. It's working.
oh, yes, so you can make copies. Thank you. All right, so Mr. Sexton was just saying that he agrees with the traffic analysis or assessment so that we can have more information in order to determine if it's going to create traffic congestion or impair pedestrian safety. So that's what he said.
Before you do kind of, can I ask you a question?
Yes, absolutely.
My name's Don Frederick from Sherman and Frederick Lane Surveying Engineering. You had mentioned number 5, in
Yep.
particular, a particulate matter study.
Yep.
I know they're gonna ask me what that is. I don't know what that is. Is that something that you have seen, or just, I'm wondering exactly what you're looking for by asking for that, just so that we could provide the right information?
So from my understanding, and correct me if I'm wrong, Attorney Costa, but the particulate matter in the air means when you are excavating, how much is being flown into the air that could travel to other residents in the area, and how far will it travel, is my understanding. Is that correct?
So I think that's a component of it. I think also, what measures might be undertaken to ensure that that doesn't become a problem. So there's a mitigation component to it as well, and I think that the mitigation component may be a large part of it. I don't know that the applicant is going to be able to deny the premise that there's going to be some particulate matter generated by an excavation operation. I think the question is, how does that get mitigated so that it doesn't become problematic for neighbors or residents that are in fairly close proximity, or sometimes further proximity from the property. So it's a study of what is anticipated in terms of particulate matter in the air, and then what mitigation measures might be employed to ensure that it doesn't become a health concern for residents.
Thank you.
Thank you. Right, so I have asked for a particulate matter in the air study be done and a traffic analysis be done as well. And with these studies, it is common that under Chapter 44, Section 53G, that in order for us, because we are not experts when it comes to these studies, but in order for us to be able to look at this objectively, for us to be able to have someone who specializes in those tests do a peer review. So we would be asking the applicant to pay for those peer review to be done as well. And I'm not sure how much it is for a peer review, how much we should be asking the applicant, whether 5,000 is enough or 10,000. I'm not sure how much the peer review process costs.
So, Madam Chair, it can be difficult to say without having the studies prepared and submitted, right? So, because we don't know what those look like yet. So I think it's sort of it's a two-step process, and whether the applicant wants to expedite it or not, I guess, is up to the applicant. I think the first part of that process is to ask the applicant whether it's prepared and willing to provide the things that the board is requesting, these two studies or these two analyses. If the answer is yes, the second question is, well, is the applicant willing to provide funding so that those can be reviewed on behalf of the board by a consultant of the board's choosing that has the expertise that the board doesn't have? The way that process works under the statute that you've been referred to is you're required to get a quote from a potential consultant. You're not obligated under that statute to comply with public bidding laws. Procurement law doesn't apply to those sorts of consultants. But you are required to get a quote, to present that quote to the applicant. That quote should provide a scope of services in terms of what is going to be reviewed and how comprehensive that review may need to be. And then the applicant has to sign off on the scope of services, authorizing the use of the funding it's providing to the town. So, but again, I think it's a bit early to know what those quotes might say, what that scope of services might be, without knowing what it is that the applicant has submitted. There's, I imagine, going to be quite a bit of difference between reviewing what could be a 25-page traffic assessment, because I have seen assessments, even though they're not full studies, that have gone 25 pages. Maybe not for a project like this, I don't know. But there's going to be a difference between reviewing that and reviewing something that is 3 or 4 pages that is not quite as comprehensive. And obviously the cost will be reflected in the scope of the peer review. So whether we accomplish that over a series of meetings, whether you, once there's, I'm not suggesting that you continue the meeting now, but once we've concluded tonight, whether you continue to a date that is 30 or 45 days out to see what the applicant submits, to then have a discussion about peer review consultants, or whether you have that discussion about consultants now and structure it so that that study or those studies get submitted, they get peer reviewed, and by the time you meet again, both of those things have occurred. You've received the study, you've received the peer review of that study, and that's what you've got before you. That's up to the board. I have boards that do it both ways. But it's also, to a certain extent, up to the applicant, and they're going to be at the mercy of whatever consultants they're engaging. They could call a traffic consultant to have an assessment done, and they could be told that that assessment is 8 to 10 weeks out, and that's going to affect the timing.
Okay. So as Attorney Costa said, are you willing to give us a particular matter in the air study and a traffic analysis study? Or are you willing to do it? So I guess that's the first thing we'll start with.
We will provide those.
Okay. And then are you also willing to fund for a peer review consultant?
Most likely, yes. I think we would, in my experience, the Attorney Costa's point, my experience is that there's some back and forth on that sometimes in terms of a peer review. I certainly had peer reviews suggested where the scope of the review was almost more significant than the initial work. It was not, it didn't make sense as to why that was the case. So yes, we would be willing to provide the reports and fund a reasonable peer review.
Dave or Glenn, did you have anything else that you wanted to look at on the 11 criteria? So we're not then coming back once they have those for another study or something else?
No, I think those are the ones that that stood out that I know I had concerns with as well. So
I agree.
Eugene?
I agree. That was the only thing that we were looking for.
Excuse me.
You may approach. Yep.
Susan Knightley.
You need to come to the mic so that they can hear you.
Hi, Susan Knightley, 32 Ferry Hill Road. I'm just a couple of things. One, in terms of the traffic and the count, I think the count is incorrect. When you look back at what they base their truck usage at, 2 or 3 trucks a day, it's annual. And actually, these guys aren't going to be doing it annually. They're not going to do it in the dead of winter, I hope. They're not going to do it on really rainy days. That's one thing. The other thing is water. Can we not look at what's going to happen to our septic systems, to our well water, and to any kind of water that the trucks have to pass over? I mean, we're fishing Aldrich Lake. I mean, what's going to happen to Aldrich Lake if one day a truck just happens to slide off the little culvert that's there and, you know, diesel fuel gets into it. I mean, I think besides the fact that this is the one of the 3 towns in Western Mass that has vernal pools where the blue spotted salamander births its young. And we have a vernal pool all over that area. And I'm a little concerned about, it's debated in the legislature now about our 50-year, 20-year, 50-year, 100-year flood maps. And those things are changing rapidly with climate change. And we just have to think about, you know, the wells and the water that's there. So I would hope that there'd be some sort of study around the water. I don't know what that would be, but thank you. And I have something to read later, but I won't do that now. Thanks very much.
Thank you.
Thank you. So number 3, Attorney Costa does say that the use will not constitute a nuisance by reason of an unacceptable level of air or water pollution, excessive noise, or visually flagrant structures and accessories. So they did provide us with the noise analysis that was done. We are asking for air particulate matter. So is there a study that would be in our purview, because we are not the Conservation Commission, that we could ask for the water?
So, Madam Chair, there's an obvious difference between surface water,
Mhm.
groundwater, water resources like
Yeah.
wetland resource areas. So I heard a reference to concern about water. I heard a reference to concern about wells, and then I heard references as well to vernal pools. So
Yeah.
those are all different things. If we're talking about vernal pools or wetland resource areas, that is a matter that's within the purview of the Conservation Commission. I don't know whether this project, if it's occurring or there was a disturbance, or the term used in the Wetlands Protection Act is an alteration of land that's within the 100-foot jurisdictional bounds of a Conservation Commission, then the applicant will be required to make either an RDA filing or an NOI filing. I don't know if that's going to occur or not.
No, it's not.
Okay.
They were out of the 100 feet.
All right. So if they're outside of that area, then they won't need to make those requisite findings. To provide a bit of additional color commentary, I heard the reference to vernal pools, but vernal pools are not always subject to protection under the Wetlands Protection Act as isolated wetland resource areas. They're different. And there's also a difference between a certifiable vernal pool and a certified vernal pool. So without getting into the weeds with respect to wetland resource areas, it sounds like that's not something that will be reviewed by the Conservation Commission. If you had significant concerns because you have some broader authority under your special permit standards to evaluate environmental harm, you could ask for additional information from the applicant. But I want to caution you about defaulting to this idea of a study of this and a study of that. It's not always a study. Sometimes it's just that you need information and you need to evaluate that information on your own as to whether it satisfies you based upon these purposely sort of subjective criteria within your bylaw. So that goes to vernal pools, that goes to surface or groundwater, surface water runoff that might occur as a consequence of relocating a roadway or a driveway. And of course, it goes to private wells to the extent that there's concern that something that might be done could pollute or could cause harm to a private well. I don't know. I have not seen anything in the paperwork I've reviewed for this project that necessarily suggests that that's a concern. I've not seen anything in this paperwork that addresses those issues head on. So if the board has concerns about those things, I think you should engage in a dialogue with the applicant and see what information the applicant can provide. And if it's not satisfactory to you, you could ask for additional information. But as you say, each of these, you've got an 11-part test for the issuance of a special permit. And almost each of these 11 criteria is purposely a bit vague, a bit broad, a bit ambiguous, and it's meant to provide you with some flexibility in how you apply them, what information you ask for to convince yourselves that this is a use that is appropriate for the location where it's being proposed.
Thank you. And when I look at number 8, I don't think I have enough information to check that box either, because it says the proposed project shall not create a significant adverse impact to the quality of surface water or groundwater during or after construction, and provision shall be made for maximizing groundwater recharge. So as you said, a study might not necessarily be needed, but more information is. But me not being an expert, I don't know what that more information is. Like, how would they provide me with enough data for me to be able to say, okay, it's not going to affect groundwater. It's not going to affect surface runoff. So,
Sure. So that is one. I was speaking very broadly about not requiring a study with respect to necessarily each and every one of the 9 or 11 criteria.
right.
That is one where I might actually look to a study because applicants will typically provide a drainage report, a study of drainage conditions pre and post construction, during construction. They'll present an erosion control plan during the construction phase to give the board a sense as to what will be done to ensure that there's not runoff, with particulate matter into sensitive areas. So I don't think I saw that in the materials that were submitted, but that is something that would typically be submitted for a project that obviously depends upon the project scope. If you're building a single family home or a duplex, that's not something I see submitted to permitting authorities too often. When you're building shopping plazas, it's a routine submittal. This is probably somewhere in between in terms of the nature of this project. And that is something that would be reviewed typically by your engineer. Some communities do it in-house if you have a town engineer or an engineering department. In smaller communities that don't have those resources, it would be reviewed by a third-party engineering consultant, the civil engineer that has experience with stormwater.
And we do not have a town engineer. We do not have a town engineer, correct? Yeah, I didn't think so. We're one of the small towns.
May I give you some information on it?
Please, yes, come on up.
I believe all of this has been presented before. Obviously, it's been a while, so I just wanted to make sure everybody is aware of what we've said or submitted to the board. As far as the Conservation Commission goes, we did have the wetlands delineated. We asked them for a request for determination to look at those wetlands. They wanted to do a abbreviated notice of resource area delineation, which is quite expensive as far as fees, and they would hire a consultant to do that. We agreed that we would do that at a point when we got closer to the boundaries. Basically, they would have somebody confirm the boundaries. But as it stands right now, we're not anywhere near jurisdictional areas or buffers or the floodplain for that matter. So at some point, we could get near their boundaries. We're not ever going to be, our intention is to stay out of all the buffers, rivers area, and so forth. To the best of my knowledge, there is no certified vernal pools on this property or that will be affected on the property by this operation. As far as stormwater goes, generally stormwater management policy will be kicked in if you're filing a notice of intent and have a increased in impervious area or create a new point source discharge, which we don't do on this project. So we have not done any stormwater reports. The intention is to contain everything on the site as far as stormwater and erosion. It's a gravel operation. So putting it simply, they're digging a hole and everything will run into that. So there's no erosion off the site or loss of recharge. There'll actually be recharge going into the ground. We've also maintained, we've done and submitted test pits and monitoring wells so that we have either found a level of groundwater or have a monitoring well in the ground that has not shown groundwater. We maintain a minimum of 6-foot separation throughout the site to the groundwater to maintain the filtering capability of the soils above the groundwater. Your bylaw does not have a minimum allowable separation to that groundwater for the earth removals. Some towns do, some towns don't. I can give you an example of the stormwater management policy for their underground infiltration areas or detention basins, allow a 2-foot separation. Title V varies from 4 to 5 feet, can get a variance to 3 feet. Other than that, there's nothing in your bylaw. We have maintained a 6 just to be consistent with other applicable engineering standards for that separation. Thank you.
Thank you.
Thank you.
Madam Chair,
Yes, Attorney Costa.
if I could just ask through you to the applicant, is there an operation and maintenance plan that has been developed for the construction phase or post-construction?
No, I don't believe we submitted that.
Okay.
What did you call it, Attorney Costa? Operation of?
So it's an operation and maintenance plan. It's often
Okay.
referred to as an O&M plan. I would agree that you see these, they're required by those projects that trigger the stormwater handbook. My understanding from what was just said is that this is not that sort of a project based upon calculation of impervious surfaces and area of disturbance. I just wondered if there was such a plan. The operation and maintenance plan would address during construction and post-construction how the site was being maintained and how any stormwater management system would be maintained. That doesn't sound like there's much of a stormwater management system here because it's not a construction project, it's an excavation project.
Right.
But I just wanted to ask the question because if there was one, that is something that the board would want to review.
Question.
Yes, come up to the mic, please.
Hello, everybody.
You can just state your name and your address.
Diane DeShays from 312 Bachelor Street, and I apologize for my voice. I am the audiologist, so I was able to take a really quick peek. I want to just make sure that you all really look at this noise study carefully. They only gave an instantaneous noise study here. It is not a comprehensive one. That will also look at the impact of all of the residents in the area, particularly up there on Tromke Avenue. We're supposed to be looking at the schools that are within the mile and how it could affect. The measurements and all that I looked at quickly are confusing. Our maximum sound level is 65 decibels. Within that, and some of their numbers, we're talking about 75 decibels, and we have no idea where those are really measured. If a comprehensive noise study is supposed to be taking place within 25 feet of, it was supposed to be from the property lines of the closest residents to the site. I have a few articles. I'm going to submit this again to you all. I can get you copies of what an appropriate comprehensive noise study is. I don't know, were you planning on having or hoping to have a peer study on the noise study, the peer review of the noise study as well?
We would have to get a peer review of it because I'm not a specialist in.
Okay, so that was planned. So I just really want you to think about that. This is not a comprehensive noise study that will address all of what could happen with the residents and all of the there's from what I understand, there's also a daycare up there. So we need to think in that just about the air and all that everything. But I just, as being an audiologist, I wanted a careful review of this. Thank you.
Thank you. So Dave or Glenn, looking at the other 11 criteria, was there anyone that you guys needed more information for? I don't know if you want to take a look at them.
Didn't see what
Yeah.
stood out.
Madam Chair,
Yes,
did you still want the title search document also?
yes, the title search document actually was something that you guys were going to have for us at the last meeting when we had to
We
reschedule
never
it, right?
received that document, so.
Okay. Do you have that document?
No.
Okay,
Have one generated. I gave the board my opinion about,
at the beginning of the meeting.
if you'd like a specific opinion generated, I can.
So you had, at the beginning of the meeting, you had said that you would suggest changing the road. So it's not on that property. Is that what you were saying for the right of way?
To the extent, so I think what we would do would be the plan that we are looking at, the mic so people can hear me. The plan, I think that we're looking at, that shows the actual physical area of the gravel way known as Tromke Ave versus the layout of Tromke Ave on the plan is from 1988. My understanding from speaking with Mr. Tromke is that that gravel area has probably shifted significantly in the last 30 to 40 years. And so what I suggested was that we would, to avoid these issues of some of these title issues that are out there about where the easement lies and so on, we could just move, first of all, have the gravel way surveyed if necessary, or have more appropriately Tromke Ave as it's laid out on the 1988 plan surveyed, and move the traveled area within that layout. I don't, so as a result, I mean, if you'd like a specific report saying, you know, that the owners of the properties abutting Tromke Ave owned to the center line pursuant to the derelict fee statute, with additional information about who has rights to use Tromke Ave as a private way, I'm certainly happy to provide that. But in light of the fact that we were moving it, it didn't seem necessary. It's easy enough to provide.
Well, because even if you move it, we have to make sure that it's not within the property of the people on the corner, right? So
Well, we would
you
move
would
it.
still need a title search to see where that property goes.
A title search isn't going to show
It's
that. That would be a
town.
survey that would
Okay.
show that. So we would move the road to the area of Tromke Ave as shown on the plan,
Okay, which was the 1988 plan that you were just speaking
1988
about.
plan. And so, you know, for all we know, we may have that, you know, have the pins put in the ground, and it may already be within Tromke Ave. But I did say we would provide a title report. Why don't I will, we're already providing these other things. I'll provide that as well.
Thank you.
Madam Chair, there's a question.
Madam Chair.
Yep, you can come up
can
to
I
the
have,
mic.
Multiple issues that we talked about. Thank you. I'm Attorney John McLaughlin. I represent the Bruffies, I represent the Troughs, and I represent this. Represent the Bruffies, the Troughs, and Miss Lambert now. So I represent more people. We have financial support from many, many people. And I just wanted to address a couple of issues as to what happened, what I've heard tonight. First off, my understanding of the amendment that was filed did not change the special permit application except for the yearly amount. Unless they're going to be more specific. Brother Counsel said we're reducing it by 25%. The application still says that they want to remove 292,280 cubic yards. But they're not going to do it 40 a year, they're going to do it at 10 a year. So all they're doing is extending the pain, as I see it. I mean, what was going to happen in 7 years and 4 months is now going to take 29 years and 1 month. They're just changing the amount they're taking out per year. They're seeking, unless I'm wrong, Brother Counsel said we're reducing it by 25%. They're just reducing down to 25% the amount that they're taking out each year. This is still a massive industrial size project that's going to go on beyond the lives of many of the people in this room. I'm 65. I don't know if I'll see the end of this. This special permit is huge. It's a massive amount of money they're going to be making for decades and decades. This is not like a 10,000 cubic yards for 1 year and we're gone. So that's the way I read the written amendment. I don't know if Brother Counsel wants to say that they're reducing everything to simply 25%. I didn't see it that way. As in regards to the written amendment, that was somewhat confusing. Okay, indeed, someone got up here and said, this isn't going to go 12 months a year. It really isn't. There'll be periods of time where there's no market for the product and where it's extremely hard to get it out of the ground. I think at best you're looking for maybe 42 weeks a year, maybe, which is 210 days. I'm taking them at their word that it's 17 cubic yards per truck. That's 588 truckloads per year. At with work days at 210 days, that's 2.8 truckloads per day. What they've neglected to say is that's almost 6 trucks trips a day, not 2 or 3, because each load is 2 truck trips. So you've got a lot of traffic here that's going to be increasing. The other thing is you should look at the court decision from 2012. That happened after days of trial of sworn testimony. And the judge said, and I'm quoting from the judge's decision, this is adjudicated and it wasn't appealed by the Tromke owners and it wasn't appealed by the applicant at that time. This is the law of the case. And the judge said, Bachelor Street is a winding, hilly road ranging in the vicinity of Tromke Avenue from just over 19 feet to just under 22 feet wide with no sidelines. There are multiple school bus stops along Bachelor Street, including at the corner of Tromke Avenue. Due to the width of the roadway, cars must pull to the side when trucks or school buses pass them on Bachelor Street. So they're asking the cars, that's what the judge found as a fact regarding this matter, on essentially the same type of special permit which was being sought. So that means they're asking, and on Tromke, it's even worse. I don't know if you've been there, but where the culvert is, it's impossible to get 2 cars. So that means people who live on Tromke, like my new clients, they have to stop and wait for the Tromke gravel pit trucks. Why? I mean, so the way I see it is people are going to have to stop 6 times a day to let the Tromke trucks go for almost every normal day of the year for 30 years. This is not a little thing. In special permit criteria 7.27 sub 7 says you can only pass a special permit that will not cause traffic congestion and there is a convenient and safe traffic flow on the adjacent streets. This is not a convenient traffic flow. Everybody's got to stop to let these guys pass. Just because you can apply for a special permit for a particular piece of property in this district doesn't mean that these streets are good for it. And this is a new special permit that's getting hundreds of thousands of cubic yards. This isn't, 10,000 up going away, or I'm just renewing one that you already granted. My understanding is they're going to say, okay, once you've got this, we've got this for 30 years, and we can keep doing it so long as we stay in compliance. So that you're going to have this forever, and this traffic is going to be there for 30 years. Everybody's going to have to pull over at least 6 times a day. I don't think any reasonable board could find that.
It is reviewed every year for a special permit, so it
Yeah,
should be renewed.
for compliance. Big deal. I mean, if you give somebody hundreds of thousands of cubic yard special permit and you say you're out of compliance with that, they'll fix it. But they still got a special permit going for 30 years. That's what you got here. And I know they've reduced it, okay? But that doesn't affect a bunch of the issues that have been raised. For my clients that are on Tromke Avenue are direct abutters to this. So the noise, I'm glad you're going to get someone to review the noise test. When it's an industrial use, frequently they use state guidelines, not just local guidelines. You have special permit criteria. It doesn't say everything's fine if they obey your regular bylaws. You could say, this is a massive industrial use. We want to make sure there's no sound problems. And then the particulates. Now, how Brother Counsel Acosta was talking about, there's other ways of mediating this. Frequently, what happens is a berm. If you're going to do a pit that's going to be there for 30 years, that's going to generate at least 6 trips a day forever, you would have a berm. It would be fairly steep on the side of the gravel pit, and then would be a gradient down to the residential properties on the other side. And usually, boards would have to vegetate that side. That would help with both sound and it would help with dust, both, if it's done right around the entire property. So that's what we should, where especially where it's intersecting with residential properties. And then what happened with the title was, I was right. They didn't have any right at all to put commercial traffic on my client's property. That's what I've been saying all along. He's not giving you the title search because the title search will show what I've said. And that is what happened here. So the only way they can get around it is to move the road.
Do you have a title? Did you do a title search?
I had someone do it, and all of the statements as to the pertinent title references were in my 15-page report that I gave you 1 or 2 times ago. Yes, and what it showed is that the easement that goes over Miss Lambert's property, who is now my client, Miss Lambert, that is only good for what it was used for in the 1930s, which was residential and agricultural, not industrial. And you list this use as industrial. So they have no right to be on my client's property with industrial use. So they're gonna have to move the road. And he said, well, we're gonna move it to what was approved in 1988. That's good, but they should do the entire road. Not only to what the 1988 approval said was, if there's further development on this road, they had to bring it out to the full width of a subdivision road and pave it. That's what they have to do. That's what this board ordered in 2010. You were right in 2010. Your own lawyer in 2010 wrote a written opinion that said, yes, if someone's going to do a gravel pit there, they have to bring the road up to subdivision standards. The problem with that is they're going to be doing that in wetlands and in a floodplain. So they're going to have huge problems. I mean, you should have them, a wetlands expert say that they could do this. It's even feasible, especially where the culvert is. The culvert goes through wetlands, literally through wetlands and through stormwater. And now they're going to have to make it much, much wider. They're going to have to kill a bunch of wetlands, try to replicate it someplace else. I don't know what they're going to do. It doesn't seem feasible. This particular property is not a good place for a special permit. I can't see how any reasonable board could say, oh, this is a good property to do this. And speaking about the culvert, one of the other issues is that culvert going to be okay to handle this amount of traffic all the time, every day for 30 years? Is it? I don't know. I mean, that is something you might want to have them give you more detailed studies on. The hydrology, I'm glad you talked about the hydrology. If you saw that we gave a report, someone volunteered, a PhD from MIT, who volunteered, I didn't pay that gentleman anything, saying you definitely need a hydrology report, especially for stormwater and surface water and underground water. It gets me to another point. Look at the paperwork that they gave us regarding what they gave for the water heights. They're dated 2010. They didn't even do new mapping for this application. They just threw in what they did last time. 2010 is a long time. I don't know if the hydrology changes that much, but they've got 2010 reports in there. You should at least say that it should be a contemporary plans and showing the stormwater, the groundwater. Okay, and Brother Counsel said, oh, I dealt with every issue before. There's a big, big, big issue here, which is 26.272, all right, the special permit condition. And it says that it must be similar in character and scale to other uses that are done by right in this district. There's nothing even similar to this at all whatsoever that's going to call for the massive amounts of work they're going to have to do to prepare the site and the industrial use for another 30 years. What can somebody do by right in this district that's similar to that? Nothing. If you recall, last time when Brother Counsel spoke to each issue, he said, oh, this is like one of the others. Literally, I think that was the quote. No, it's not like anything else. It's a poison pill. It basically, for their project is not like anything people can do by right here, not in scale or in scope or in character at all. So they just can't do it in this this district what they're proposing for the scale of this particular project. Reports, I'm glad we got the report. I do remember that in April 1, they said, we'll get you the report in 30 days. So it's here. It's better than not showing up at all. But I do think when it comes to the traffic, that that's extremely crucial because especially with judges finding a fact which was not appealed. And the fact, the other thing to really have to address is that point that to issue this special permit, they must put Tronky Road to the full width and paved. Now, I know Brother Council is going to say, well, the planning board didn't have the power to do that in 1988. Maybe not, maybe they did, but it wasn't appealed. That is the approval that was done. It's like somebody finding a problem with the special permit that was issued 2 years ago. It's too late. The special permit's done. This was approved decades ago, and Trotskys, who owned the land, lived with it. They said, okay, you know, I don't know if that's right with the law. Maybe they did or they didn't, but they had a chance to appeal it, and they never appealed it. And your own lawyer in 2010 said, and I've said, reading it, that the only way they can do this project is to make it the road fully to the width of the subdivision and subdivision standards and pave it. They're going to have huge problems doing that. The other boards, I mean, we now have them saying, if I recall them saying, we're going to go to the wetlands commensurate with you. The statute doesn't require them one before the other, but they were going to go to the boards. They said it was weather. The weather was bad, so they couldn't. Now it's saying it's going to cost money, so we're not going to go to the wetlands people to do all those plannings. Just a point that I recall. And also, there's still the issue of the court in 2010. This board seemingly was saying that they would have to go to the planning board to get a special permit to bring that much earth over the floodplain, which part of the road is in the floodplain, which is an unusual thing, I understand, but that's seemingly the language you have. So I've been talking mostly about the special permit criteria. You know, there should be a berm, you know, the road's got to be bigger. They've got to get off my client's property for any use, commercial use. But we should also look at some of the stuff with the application itself. I mean, they initially said that they're doing this so that there'd be Title V availability for sand. I think we've heard tonight, there's other places available, and there's many, many places with an easy drive to get Title V sand. But your bylaw says that they have to give you a statement as to what the purpose of this project is for. What is it? I mean, this goes way beyond what anyone would need for Title V for Granby. So what is it? I mean, that is an unusual provision. Not everybody has that, but I haven't heard a statement. Is this going to be sold in other towns for commercial uses? You know, what is it? It's not going to help Granby at all. It's not going to give you a lot of jobs out of town people. And it's just going to make money for the landowner. And I don't see that there's much benefit at all to the town of Granby. And not every town has such a provision, but you do. So they're supposed to tell you, and they haven't done that. Also, in their application, I'm getting now into the 5.8 stuff. This is 5.8 is the stuff that's peculiar just to the gravel pit, not your special permit criteria in general. But there's a provision of 5.8 that calls for restoration, okay? And a bond to pay for the restoration. This restoration, this is going to be the size of a stadium when they're done in 29 point something years. And they're supposed to, I'll give you the exact, replace with loam or topsoil of 4 inches of pre-existing topsoil. And they are required to undertake planting of the area to a suitable cover, including trees, okay? So, and, you know, when they did their application, they said, these are the points for 5.8, they left out the bond. That's going to be an extremely expensive bond. And are they going to get it? Are they going to redo every area each year that they get back? Otherwise, the bond's going to have to be significant to make sure when they get done in 20 or 30 years, they don't leave you with just a big hole in the ground. Because that's what could happen unless you get a significant bond to make sure that they can pay if they don't restore the area. And you should talk about restoration. How many trees? Where are the trees going to be located? They've done nothing with that. When they did their application, they sort of left off restoration. They didn't really talk about it. So the other thing I wanted to address is the 2010 situation. In 2010, and I guess it was Miss McDowell, who was sitting in one of your chairs 10 years ago, She made it clear that what happened in 2010 was they had a gun at their head. They asked for these studies and they said, we're not giving you any studies. They wouldn't do it. And normally that could result in a board saying, well, we're not giving you your permit if you don't give us any studies. But they didn't, because they were left in a situation where they had closed the hearing and then more than 90 days went by before they gave a decision. That's a bad situation to be in. And they believed that they had a gun at their head. They either had to give a permit with conditions, or that the applicant was going to argue something called constructive approval, meaning that I got what I applied for. So you better work with me, or else I got what I applied for.
I guess, why do you say that? I'm concerned as because it's just putting words out there. I never heard any of the other board members that were on the board at that time say that they felt like they had a gun to their head.
Well, Mrs. McDowell's letter seems to imply that. I mean, and I've spoken with her. That's why I'm saying it. She was there. And I gave lengthy excerpts from what happened. And what happened was they had minimal hearings, closed the hearing, and then the neighbors came up and said, what have you done? But it's kind of too late at that point. So they took evidence that was probably not admissible. And
So Miss McDowell stated she felt like she had a gun to her head.
no, that's my words.
Okay,
But
that with all due respect, sir,
Yep.
that is the point I'm making. Those
Well-
are inflammatory words.
okay,
That's all. 'Cause
those are my words. No, she would never say that.
That's what I'm asking.
Okay. No.
'Cause to hear that, that's what was being implied. 'Cause
No,
I know one of the other members that was on the board, and he basically, he said what the issues were at the
Well-
time that occurred, but didn't say he felt pressured or anything like that. He just basically said, we made a wrong decision. We shouldn't have listened to our attorney.
we pressured. I mean, there's a letter from the applicant's attorney that says,
Again,
Yeah.
I'm stating the same thing
Right.
that kind of
Okay.
stated that. That's why I'm bringing it up. 'Cause
That's true. No, she would
you
never
put
say
out
that.
words like that, saying she felt like the
No.
board members felt like they had a gun to their head.
No.
I think it isn't.
She
a fair
did. She
statement.
that was my spin on it. You know, I'm a lawyer. Okay,
No.
that was my spin on it.
That's why I asked.
Okay, that's right. But if you read the letter from the applicant's attorney, he basically said, "You guys waited too long. We'll work with you, but I can get what's known as constructive approval. I'm sure Attorney Costa can tell you about that. It's a bad thing to get around constructive approval. If you've got an applicant who says, we'll take conditions and we'll run with it, then you'll give them conditions and run with it because you don't want to fight over constructive approval." So that's the situation they were in. I said it's a gun at their head, but they were constrained, really constrained. And they had asked for reports that they didn't get. And the applicant and presumably the property owner wouldn't give it to them because it might not be good, especially when you consider what the judge said in her decision after days of trial and sworn testimony. She said that the roads are so bad, people got to pull over for these trucks. Why is that in compliance with your special permit? It isn't. No board could find that that's a good, reasonable traffic flow. That's congestion. And the other issue, number 2 of your special permit criteria, it's got to be like something that they do here by right. And there's nothing like it. So I don't see any way that this could be granted. And I think I've said enough, but thank you for hearing me. Thank you.
Thank you.
Folks,
John.
with all due respect, please, we're having a public meeting. I don't think it's proper to clap one way or another. Okay, it's just we want to give people the opportunity to speak and voice their concerns on the issue at hand.
Thank you, God. Attorney Costa, could you give us some advice?
Concerning.
So there was a lot there. So I know we're looking at 6.27 criteria, and there's 11 things that we need to make sure are being upheld. But then we also have the earth removal bylaw, which also has the board, which is the Board of Selectmen, also looking at that. We also have the noise ordinance that we have to look at. There's a lot. So when we originally looked at this, it was 11 criteria of the 6.27. we're also looking at the earth removal, correct?
That's correct. So this is not unique to Granby. It's not unique to earth removal. There are many instances in municipal ordinances and bylaws where there are self-contained sections of those ordinances and bylaws that regulate a certain use. Think about an open space residential development or a cluster development. You may have a section of your bylaw that deals with those. Think about a solar photovoltaic system, a solar facility. You may have a section of your bylaw
Yeah.
that deals with those. But it may also state within that section, in addition to providing various criteria that must be satisfied that are particular to that use, it may also incorporate the requirement of a special permit and therefore incorporate the more generic special permit criteria that you've got pursuant to a different section of your bylaw. And that's what happens here. So you have section 5.8. It's entitled Earth Removal Bylaw. It doesn't do much in terms of criteria. There's not a section that says you've got to make the following 11 findings. But what it does do is it has a list in section 5.81 under procedure of submittals that need to be made by an applicant. And then in section 5.83, which is called limitations, it says that a special permit granted shall impose reasonable conditions designed to safeguard the neighborhood and the town, including specific conditions pertaining to the following. And then it has a list of A through N, various topics, some of which were just referenced by the previous speaker. It also includes a bond requirement, also referenced by the previous speaker. So these are things that are particular to earth removal. It wants to know the type and location of temporary structures associated with the removal. It wants to know the area and the depth of excavation. These aren't generic special permit standards. These are standards that are specific to earth removal operations, which is why they're in section 5.8. So you have to make findings that these required submittals have been made. You have to go through, to the extent you're going to grant a permit. Obviously, if you're not granting a permit, you don't need to condition it as provided in section 5.83. But if you are going to grant it, you've got to go through and ensure that these conditions have been satisfied or that you're going to condition an approval accordingly. Things like determining the distance of excavation from street and lot lines, things like determining that there's proper fencing being provided, things like, again, something referenced by the previous speaker, that there'll be replacement with loam or topsoil of 4 inches or pre-existing topsoil condition over the area of removal once the removal is complete. You would need to condition your approval, again, presuming an approval, not saying there should be one, but if you issue an approval, you'd need to condition it consistent with these requirements. So you have to do that in addition to the 11 criteria that we've been discussing off and on over the past hour or so, which are the more generic special permit criteria. You need to make those 11 findings. If you make those 11 findings and you're prepared to grant the special permit, you then have to shift over to the earth removal bylaw and appropriately condition it consistent with these additional requirements.
Okay.
Make a statement.
Yes, please.
Earth removal requirements, our application did, as far as the earth removal requirements go, we did have a project narrative that addressed each of those items in section 5.83, based on what the section that you were just referring to.
And that is accurate. The applicant's submittal materials had this document called Earth Removal Permit Narrative, and it does walk through those criteria.
Thank you. Attorney Costa, do you mind just holding that up? Because between everybody who has given us papers, there's a lot here. So if I can just see what the front of it looks like.
Sure. It's a document that's entitled Earth Removal Permit Narrative. It says centered on the page just beneath it, LJ Development LLC Earth Removal, and then it has a reference to the map and parcel number. And then it begins by saying the following is in accordance with the requirements of the Granby zoning bylaw section 5.8 earth removal, and then it walks sequentially through the numbered criteria. It was toward the end of the December 12th, 2023. I think that was the original submittal made by the applicant. It was toward the end of the PDF version that I received by email.
Got it.
Madam Chair, I have a copy
No, I have it right here. Thank you very much. All right. All right, so I just want to the other board members, make sure that we have a full list of what we need in order to make an informed decision on this. So we have particulate matter in the air, where we want them to look into that. We have a traffic analysis. We are also asking when it's time, once we get those analyses, that we have funding for our own consultant, which the applicant has been willing to do for reasonable peer review. As far as the drainage report or erosion control plan, as discussed with Attorney Costa, they are over 100 feet from any waterway or anything like that. And they're digging a hole in the ground, not surrounded by anything. So they wouldn't need the information, correct?
So I think that's correct based upon the representations made by the applicant. But
Okay.
as a board, you don't necessarily have to take those representations at face value. Having said that, I can tell you I'm not an engineer, so I can't. It's not a legal question. It's a question for an engineer as to, based upon review of the site plan, whether it's within the 100-foot jurisdictional bounds, based upon the stormwater standards, whether any of those apply in light of the nature of the project that's being proposed. Legally, I can tell you I understand the stormwater standards in the handbook, and I understand when it does and doesn't apply. So I have no reason to doubt, based on the nature of this project and what's been represented by the applicant's engineer, that it may very well be that the stormwater handbook is not triggered, and the nature of the project doesn't require the design of a true stormwater system. And so you're not going to get that information. But again, I'm not an engineer, so I can't say that definitively.
So then would it be a peer review on our end to make sure that their engineer is within the scope of that?
Right. So you've talked about peer reviews of the two forthcoming studies. So you're talking about a peer review of the particulate matter study and a peer review of the traffic assessment. There's also a noise report that's been submitted, and
Which
we heard
needs
from
to
at
be
least
peer reviewed.
we heard from at least one resident to request that be peer reviewed. And I think, Madam Chair, you said that it would be, but again, that has not been posed to the applicant. And now we're talking about engineering components, site design. That's something that could potentially need to be peer reviewed. And I don't know that I know enough yet, but it sounds like I'll see it once I receive the materials from the applicant's counsel about this title issue. So I know we referenced it a couple of meetings ago, but as I understand it, there's both a title component to it, but there's also an on the ground component to it. As the applicant's attorney properly said, the title's not going to show whether the roadway is within the bounds of the layout. That's something you're going to see on the ground, and is going to be verified or not by a survey that's done. So I don't know what may be needed, and this is something that I ought to be able to do in terms of a review of the title work that's submitted to determine proper rights within Tromke Avenue for the applicant to use it, and whether that runs afoul of rights that other adjacent landowners may have. But then there's a second question of the location of the existing traveled way today within the bounds of the layout of the roadway, and that could be a condition of approval if the board opted to grant the permit. It could simply condition the approval on relocating that roadway to within the layout, presuming that the applicant proves the right to use that layout.
Okay. And I know the 2010 court case keeps getting referenced. So would the culvert over the waterway have to be replaced based off the previous court case? Or are we supposed to be looking at this without that court case attached to it?
I think it's important that you look at this case to a certain extent in the context of what the housing court said. The housing court was not evaluating this particular project presented to you in 2023 and 2024, but it was reviewing a similar project by the same property owner on the site, and had much to say concerning your bylaw and the applicability of certain provisions of the bylaw, and ultimately the decision that your predecessor select board members made when they issued the special permit. Special permits are entitled to a great degree of deference, so it's not commonplace for courts to second guess special permit granting authorities, whether they're grants or denials. Far more decisions are affirmed or upheld than overturned. And in fact, if you read the 2010 court case, I think it was 2012 by the time it was decided, the 2012 decision, you'll see that the judge actually began over the course of several pages discussing the typical deference that's entitled, that is due a special permit granting authority, but then ultimately proceeded to say in the next sentence or the next paragraph, nonetheless, in light of the facts that were before the select board at the time, the court simply couldn't find that the select board was justified in granting the permit, and highlighted certain, I think it was 4 of those 11 criteria that we've been referring to repeatedly tonight, that the court determined the board was not justified in finding that those standards had been satisfied. So I think that that's instructive for the board. Again, doesn't dictate the outcome of these proceedings, but it is instructive for the board in reminding the board what it needs to be looking at, and also reminding the board of the degree or extent or strength of the evidence that it needs to be relying upon if it's going to grant. And again, I'm not saying it should or shouldn't, but if it's going to grant the permit again, or in the same manner as it did a decade ago, it needs to correct the mistakes that were made a decade ago. And if it can't correct those mistakes or can't make the findings that were made a decade ago, it shouldn't issue the permit.
Madam Chairman?
Hold on one moment, please. And one of the mistakes they made in that was, or not so much a mistake, but was that not the judge finding that they said, or the judge said that it had to be brought up to substandard level? Or no, not substandard level. It had to be brought up so that it was 2 lanes and they widened the road.
So this is something that my understanding had arisen, and you heard previous speaker, counsel for some of the residents refer to an opinion that was given by counsel at the time. I actually have not seen that opinion that was provided by counsel at the time. At this point, it's 12, 13 years ago, but I've not seen it. But my understanding is that opinion was issued to the board, indicating that consistent with a planning board approval that it issued in years prior, if there were to be further development off the roadway would need to be improved to be brought into compliance with subdivision standards. The court didn't actually say that needed to occur because the board had already said it needed to occur, right? Remember, the court was reviewing the decision of the board granting the permit. The board had already said it needed to be improved and brought up to snuff. So when you look, I have the decision in front of me. When you look at page 8 of the decision, numbered paragraphs, paragraph 17, it says, if allowed to act on its special permit, Stony Hill will be required to upgrade Trompke Avenue to subdivision standards before beginning earth removal operation. So it was a condition of approval already, and the court simply acknowledged that was going to be required. It did go on to talk about the fact that widening and paving Trompke Avenue was going to affect the neighborhood. So that is something also that should be considered in that context. But that was where things stood back in 2012.
Thank you. Susan Knightley, you can come up.
Susan Knightley, Ferry Hill Road. I'm not going to tell you anything you haven't already heard, but I've wanted to put it in writing and read it to you. So I just wanted to really thank the board for hearing so many residents. who opposed the Tromke Avenue sand and gravel pit and we shared our concerns during the past several special board meetings. We're so grateful to live in a community where we can step forward and express our concerns. Thank you. We wanted to further put on the record that we're very concerned with the very real impact this project would have on the health and welfare of local residents, wildlife, and the wetlands. Bachelor Street, so beautiful, is designated as a scenic highway in Massachusetts. It's already a challenging place to walk and safely. Many of us do so every day. We had hoped the traffic road study as well as road suitability study would have been done prior to your vote on this, and we hope that it will be. As a special permit granting authority, you required a copy of said applicant to be sent to the Board of Appeals, the Planning Board, the Board of Health, and the Conservation Commission for their review. To that end, our Board of Health noted many important health and safety issues and made many strong recommendations against the approval of this special permit application. If certain studies required do not meet the Board of Health concerns, the Planning Board voted in 1/22/24 to recommend a peer review by a civil engineer. We were discussing that. Thank you. Further, the Conservation Commission said that they'll require an ANRAD and stormwater pollution prevention plan, but not until after the project is potentially approved. That doesn't seem to make sense to many of us. We wonder why it would be afterwards. But where are the studies that determine the long-term environmental impact of removing more soil in this sensitive area? After several public hearings, the applicant LJ Development LLC has only been asked to produce this noise study and the title search, or now we have some other requirements tonight. Thank you. We are extremely concerned that without several critical studies, the Select Board will not be able to make an informed and safe decision for our entire community. We sincerely hope that you, the Select Board, will consider and be informed about all 11 criteria. Thank you. We hear that you're really exploring that in our Granby bylaws 627 before you vote on this special permit. As the town special counsel advised, even if one of these was not met, you would be within your rights to disapprove the application, if I understand that correctly. We assume that you would protect us by not approving it if any of the 11 criteria are not met, in particular number 3, that the use will not constitute a nuisance by reason of an unacceptable level of air or water pollution, excessive noise, or visually flagrant structures or accessories. Our bylaws are passed by and for all of us, and they are what protect the residents of Granby. We hold them dear, and we assume you do as well. You have been elected to do so. You are our defenders against what would harm us, our health, our clean water, and our clean air. Please consider all the legal and binding bylaws. We urge you not to approve LJ Construction Special Permit for an industrial sand and gravel pit unless all criteria have been researched by independent experts, approved by you and our Board of Health. Those studies would include a peer review by an independent civil engineer. Thank you. An ANRAD and stormwater pollution prevention plan prior to approval that would include details regarding the ongoing monitoring of the site. Thank you. A hydrological study for the wetlands and Bachelor Brook and water table analysis, please. A traffic study for Bachelor Street and Tromke Avenue to include core samples of roadways. Thank you. A noise study to include traffic noise levels analysis and documentation. Thank you. Environmental impact study, air quality study. Thank you. Note that per the bylaws, the applicant does not have to respond to our requests. They are only required to respond to those requested by you, our Select Board. These studies are warranted after significant concerns were raised by the citizens of Granby within the parameters of the application. Thank you for hearing us.
Thank you. Rich? Thank you.
Rich Stomaraki, 428 Bachelor Street. First of all, I'd like to say that there are no gravel pits that take out 10,000 cubic yards that travel Bachelor Street now. There's zero. The first thing I'd like to do is I'd like to hand in some documents. One of them was the Board of Health letter that the applicant's attorney held up and said, look, it's not even signed. I did get the Board of Health Chairman, Dick Bombardier, to sign it. Also, I got the Conservation Commission letter signed by the Chairman of the Conservation. And I'll throw in a Planning Board letter too. So I wanted to hand those in. The next item was, these are out of order, was a letter I received by filing a public records request with the town for the covenant, which was issued in 1988 in connection with its approval of a 10-lot subdivision. Here it is. Okay, what happened was the Board of Selectmen at the time asked their special counsel to determine who was responsible for paying Chunky Avenue roadway improvements. I'd like to just read a little bit of it. This is from the attorney to the Select Board. This letter is in response to your request for my interpretation of a covenant which is included in the approval of a subdivision plan, a copy of which is enclosed. Now, this is the exact wording that's on the deed to, it's on the site plan approval. And I'll read it. Any development beyond existing 10 lots requires that the road, Chunky Avenue, be upgraded to the town of Granby's subdivision standards. Said cost to be borne by the residents of Chunky Avenue, not the town of Granby. It seems logical to assume, however, that the planning board's concern was for the increased traffic which would result from the potential future development of the property and which would warrant improvements to the road. So basically, the important letter that was included in that request that I got was the last letter. It was written by the planning board to the select board. And I'll just read a portion of it. It says, the planning board is in receipt of a letter dated September 13th, 2010 to the select board from attorney David Martell, presenting his interpretation of a covenant, which is included in the approval of a subdivision plan granted by the Granby Planning Board in 1988. The covenant, as it relates to the proposal for a gravel pit and the use, conditions, and upgrade of Chunky Avenue are of concern to the planning board. As the proposal for a gravel pit progresses through the permitting process, members of the planning board wish to emphasize the importance of the enforcement of this covenant. The planning board evidently in 1988 considered and approved the development of Chunky Avenue subdivision roadway and associated infrastructure as adequate at that time. But that may but that any future development of Chunky Avenue would require the upgrade of some, not by the town, but by residents of Chunky Avenue. The planning board is requesting that, as the select board renders its decision on the pending application, enforcement of the covenant be required. Okay, so the planning board really didn't want to write this letter. The Pam Mayu was one who was on the original committee, and others were, they also supplied the minutes of the meeting that took place, and they more or less encouraged the chairman of the planning board to write this letter. the last sentence says, during the discussion of this at the meeting of the planning board on September 13th, 2010, it should be noted that the chairman felt that the legal opinion letter from Attorney Martell noted above was sufficient for the Board of Selectmen to enforce the covenant. So there's no question that the covenant should be enforced. Any future development on Chomke Avenue would require subdivision standards be adhered to. The next letter is the letter that was talked about from Mary McDowell. Now, I just want to, Mary McDonald was a highly respected select board member. She was on the board at the time that the board voted the first time. Now, she says, the select board requested 3 important studies to be conducted before making a decision. Those studies included 1, an aquifer 100-year floodplain study, 2, a vibration, traffic, noise study, and 3, a culvert study. For me, this decision was critical in making an informed decision on this permit. I did not want to grant the permit without knowing the results of the studies. Unfortunately, we never received any of the requested studies because we had closed the public hearing on June 29th, 2010, and as of October 7th, 2010, we had not made a decision within the 90-day statutory requirement. Consequently, the lawyer representing the applicant informed the board that due to our inaction within the statutory time period, the application had already been granted. So what the attorney was talking about was basically true. The last paragraph Mary wrote, she goes, in conclusion, you might ask why I am doing this. The reason is simple. I left Granby, but Granby didn't leave me. She happened to move out of town. I still care deeply for the town I resided in for 35 years. This gravel pit is going to adversely affect the residents who live in its proximity. Put yourself in their shoes. If you do that, you will make the right decision. Thank you for your consideration, and I sincerely wish you good luck in your deliberations on the current application. So I think that letter speaks a lot for the residents who are opposed to that pit. The next comment I have, I want to comment on the gravel pit renewal for Chartier Orleans, only because it's important when I discuss the next letter. This gravel pit renewal, I do not understand because it's very confusing. Last year, Chartier Orleans was authorized to extract 5,000 cubic yards a year. You look at question 4 on the application, it says, specify the amount of yardage of materials removed from this site during the past 12 months. They have 10,000 cubic yards. They violated their permit by 100% last year. They were only allowed to take 5,000 cubic yards. They admitted right here that they took 10,000 cubic yards. Question 5 says, approximately what amount of materials do you anticipate removing in the next 12 months? Then they say 10,000 cubic yards. Now, the applicant said at a prior meeting that this gravel pit was phasing out and that he wanted to take up the slack. Now, how do they phase out when they asking for a double amount of cubic yards? It doesn't make sense. But if you look at the second page, I don't know if the select board missed this or they took it into account. Item 8, it says no limit be imposed on the rate of excavation per year. This rate is in reference to the time only. The amount of material yardage is estimated at 5,000 cubic yards. So the select board put a condition, it looks like, on how much they could take out each year. It says 5,000, but they asked for 10,000. So I don't know what the story is, but the reason I brought that up was because I want to comment on the letter where the applicant says they reduced the yardage from 40,000 to 10,000. Now, any gravel pit application, there are two numbers you have to take into account. You have to take into account what they're asking for on a yearly basis and what they want to take out in total. This letter is inadequate in that it only talks about reducing 40,000 cubic yards to 10,000 cubic yards. The second part, which you should be really concerned about, is that they should take 75% of the original 292,280 yards, and that comes to 73,070 yards. So in this letter, it's very important that if you approve this, you say they're allowed to take 10,000 cubic yards out a year, but in total, they can take out no more than 73,070 cubic yards. That would bring them to 7 to 8 year life, which is what they had originally. Now, what's wrong with this letter is that the person who did it said that there'll be 2.3 trucks per day. That's totally wrong. Number one, he took 52 weeks in operation. He quoted the applicant's attorney was quoted in a newspaper as saying that they would only take gravel out of the pit for 10 months out of the year, not 52. So that's an error. And as was already brought up, you have to multiply whatever he came up with times 2, because every truck that leaves full has to come back empty to get another load. So again, I don't know if there was an error made on this chartier application or not, but if you take 10,000 cubic yards, first of all, I want to mention that I don't think I mentioned this once before, that it's very important to get a visual of how much gravel are we talking about here. 292,000 yards is equivalent to 58,000 cars, the volume of 58,000 cars piled up on top of each other. That's how big a hole you would have, 58,000 cars. Now, even on this letter, he came up with 2.3 trucks per day. So with my calculation, you not only have to take the gravel trucks of the Tromke application, you have to add the gravel permit, the gravel that's taken from chartier landfill, don't you? Because the danger is you're doubling the amount of trucks. So if 10,000 is correct from chartier and 10,000 is correct from Tromke, you're talking about 20,000 cubic yards a year. And that would be 12 truckloads a day, not 2.3.
Rich, the address that is on the Chartier Orland gravel permit, what address is that?
The what?
What address is on that permit application that you have in front of me? Because you started off saying that there is no operating gravel pit
Right.
on Bachelor Street,
It's 232 Bachelor Street.
but you just started off saying that there wasn't, correct?
There is.
Right, but you started
There
off your
should
statement.
legally, there shouldn't be. It looks like he illegally, I mean, he had a permit for 5,000 last year. And the select board limited what he could take out this year, even though he's asking for 10. The select board signed it as a condition saying he can't take out more than 5. So he's not taking 10.
I just wanted to clarify
Yeah.
for everyone, because you said there wasn't another one operating, but there is one operating. So I'm just clarifying that for everyone.
He's operating, yeah. I
Yes.
meant, he's not,
Okay.
yeah, he's operating. There is another gravel
Right, I
permit.
didn't miss that, right?
No,
Okay,
correct.
Yeah,
I just want to clarify.
but let's see. Okay. Okay, the last thing I just wanted to bring up, at at a prior public hearing meeting, I forget which one, we had so many, but it was the one where the applicant's attorney spoke at the end of the public hearing, so we didn't have a chance to respond. I just wanted to respond to two items. The attorney said that all the residents on Choctaw Avenue were in favor of this gravel pit. That's not true. They're not all in favor of it. Plus, he said the only difference between the 2010 application and this one was that in 2010, the cubic yards were, in the 2010 one, were taken out, would be extracted a lot quicker than what's asked for now. But that's not true because the one in 2010 was also limited to 40,000 cubic yards a year. No matter, that one was limited, this one, hopefully, well, originally was limited. So there is no difference. There's very little difference between the 2010 and now. So I want to just point that out. But I found it odd that Chartier all of a sudden would ask for 10,000 cubic yards. But that was all I
Well,
had to say.
they could be just deciding they're not gonna keep on doing it that much longer. There could be many reasons why
Yeah,
they decided to do that. I can't speculate, but there's, I mean,
but
they have the reasons, I'm sure.
did you intend to limit it to 5,000? Because that's what the application.
That's what it's on the permit. It's,
Yeah.
yes.
Okay. You know, I wonder, will you do anything that, it seems like they were in violation. They took out 10,000 last year when they were only supposed to take out 5.
Do you have the permit from last year? This is
Yeah.
5,000?
Yeah,
Take a look at that.
okay, good, thank you.
Madam Chairman, just bring up one motion that when meeting this, sound Tim.
If you can just give the board a minute, we're just trying to make sure that we have everything that we need in order to make a decision. And I do believe about the hydraulic study, we did say that they weren't within the 100-foot zone. So I guess I'm just confused because I don't want to overstep my jurisdiction either as a select board member, because if they're not within the waterway, I don't think we have jurisdiction to ask for that. Is that
So
correct?
Madam Chair, I think this goes a bit to the definition of what a hydraulic study is, right? So
Okay.
are we talking wetlands and wetland resource areas? Are we talking
Okay.
wells? Are we talking concern for the culvert and just the general flow of surface water or groundwater? Those are all different things. Some of those things are
Right.
within Conservation Commission jurisdiction, namely the wetland resource areas. The others aren't necessarily within the Conservation Commission's jurisdiction.
Okay.
They're all to a certain degree within your jurisdiction because you have the ability in evaluating a special permit application to determine whether there will be environmental harm, because that's one of the criteria.
Right.
It may also be that you want to, I mean, we've talked about a lot of different studies and
Yeah.
potential peer reviews. We're talking about noise, we're talking about traffic, we're talking about particulate matter, we're talking about engineering. It may be that, for example, once you complete an engineering peer review, your engineer may raise some red flags for you and say, you've got to look more closely at hydraulics. You have to do a closer analysis of the culvert and its ability to support the additional traffic. And the engineer may say, that's beyond my purview. You need an additional consultant to review that. So it may be that you're going to do some of this sequentially, or the engineer may say it's perfectly fine and it's not something that requires further review.
Okay. So would the board say at this time, would it be safe to say that we would like the particular matter in the air study done, the title search, which the applicant's attorney had said he's going to give to us, the traffic analysis, and the engineer study done at this time, and then and the noise. Sorry, yes, but the noise would be a peer review because we already have one, or should.
No, that's right, Madam Chair. You have those others.
So those are the studies that we need.
Correct. You have the
Okay.
noise report already. So
which
you
would need to be
you
peer
can you could debate whether to submit that to peer review at the appropriate time.
Okay.
Or you could submit it to peer review now. Again, this goes back to what I said at the outset in terms of how you want to sequence the submittal of these additional materials by the applicant and then peer reviewing those. Do you want to wait till you get them, review them, and then have a further discussion at a continued public hearing? And at that time, determine what needs to be peer reviewed and to what extent? Or do we want to have that discussion tonight? That's up to you.
Can I ask a question? You just
Yes,
you were going
absolutely.
off. You said 1, particularly 2, title 3, traffic, and you said 4, engineering study.
Civil engineer, so that would be a peer review because you already have your,
So on the
so that would be a peer review one, sorry, that we're asking for. Yeah, because,
particular to that, that is what's on everything that's been submitted so far.
say it again, I'm sorry.
You're looking for a civil engineering, sorry, a civil. The question was that you said engineering study.
A civil engineering study.
So
Yeah.
I wanted to know what that was, but it sounds like you're saying you're going to take the whole application and give it to a civil engineer for a
For a peer review, correct.
Not that we need anything particular for that review. They're going to do it on what we've submitted already,
Right,
plus this other stuff. That we have.
yes.
Thank you.
So that one would be a peer review. In which the civil engineer can tell us whether or not the culvert, or will advise us if it's within their purview or not, if the culvert needs to be brought up to subdivision standards. Right. So does the board want to wait until those additional studies come first before we ask for peer reviews? Or do we want to do the peer review of the civil engineer of the project itself, as well as the ideology, sorry, since we have both of those? But again, we would need a source of funding for that, which we are asking the applicant to, under chapter 44, section 53G, supply the funds for that.
Correct.
Okay.
I would say that we get all of them in, everything that we're requesting, have that come in and then send it out for peer review. Because I think at that time too, when you do that, there is a cost to that. And I think they can take a look at what the peer review would cost, and we can tell the applicant at that time what the cost would be. Instead of just keep on, kind of piecemealing them together. It's pretty hard for us to say at the end of the time what would be the cost of peer review.
For all of this.
Right, so if we have them all together and we submit that for a peer review, we'll have an idea what the cost would be at that time.
And does the board want, again, we would have to clarify what we're looking for in the hydrologic study, because wetlands is underneath the Conservation Commission. Vernal pools that are certified is under the Conservation Commission, which we don't have that there that we know of in that area. He did, the engineer did speak to the wells, that they have a monitoring well on site, right? Where it's a minimum of 6 feet separation from the wells as far as where they are going to be digging, correct?
Yeah, there's 4 of them on the site.
And there's 4 of them on site, which they are monitoring. And when you say monitoring, are you testing the water for matter?
For level.
Oh, for levels,
Yeah.
okay. Whether or not you are getting down into the groundwater. Okay. So as far as drainage report and erosion control, we said that there was no stormwater reports because we're keeping it contained on site. Is that?
I think, Madam Chair, that this is something that your civil engineering consultant
Okay,
will
thank you.
address. When they
Okay.
review the plans, they will determine whether there's more required to address stormwater or not, and they'll make recommendations. It tends to be a back and forth after that initial peer review. It's not a one and done where
Okay.
the peer reviewer looks at a report and provides a report of his or her own and then walks away. It tends to be that they provide a report and then there's communication between your consultant and the applicant's consultant. The applicant's consultant attempts to address the concerns that are raised by your consultant. They continue to go back and forth until either everything is addressed or your consultant reports that they simply can't address it and makes a recommendation to you to deny or to condition your approval.
Okay. Yes, you can come up. Sorry, I just,
We're talking about
See, no, Madam Chair, there are some people in the back who've been. waiting,
Okay.
so.
thank you.
when we're talking about the application, I mentioned this in one of my memorandum, but the soil testing information that they've given us, that they're utilizing for keeping so many feet away from groundwater, is from the last application.
Of
It's
from-
2010. They really should do a soil testing test now, not, 15, 14 years ago. This is all they just handed in what they did last time. So that's Appendix 2 of the application is 14 years old. All right, so that's not a good result. Okay, in briefly reading, I'm not an audiologist or understand the engineering behind the decibels, but please note, in Table 2 of the document we received tonight, talks about a screener, okay? Reading the earth removal permit narrative that they gave with the application, the method of removal, they say they're going to be using loaders, excavators, bulldozers, and dump trucks. Where's the screener? All right. Your earth removal permit talks about earth removal. It doesn't talk about any processing. A screener is a machine that you would put earth in with, and there'll be different screens so you can get different granulates that you can sell. Certain screeners are extremely loud, and it says screener here. There's two kinds of screeners. Some screeners are just gravity fed, and you put them in. Some are machines that make a lot of noise. They basically shake stuff. So is this screener that was tested a mechanical one, or is it simply a gravity fed one? It doesn't say. Also, more importantly, how do they get a screener? Where does that's earth processing? That's not earth removal. What's next? A rock crusher? Are they going to say we got a special permit for hundreds of thousands? We need a rock crusher too. I mean, I could be wrong. I just went back to read the earth removal narrative, but I don't see anything about a screener.
We are not screening on the site, if that makes it easier.
Okay.
Well, okay. Well, it was in the sound testing, so they were thinking about it at one point, I guess. But so it's strictly earth removal, no earth processing. If that's what the applicant stands by, that was my concern. But the other thing is, these are very old.
Thank
Can I
you.
address that,
Uh,
please, because I brought it up a couple times on the testing?
Yes, that will be fine, but I want the gentleman in the back who's standing up to talk after you,
Sure.
if that's okay, because he's been waiting for a while.
The attorney is correct. Those tests are for the soils, and they were done in 2010. The soils have not been disturbed, so those soil tests are still good. Monitoring wells I'm referring to were installed in June of 2023, so it is current,
Okay, June of
and
2023.
they can be tested again ongoing for levels of water. Thank you.
Thank you.
That was,
Sir, come on up.
that was the rules.
Yeah, the wells were tested in, you said put in June of 2023. And the soil is because it hasn't been disturbed. Sorry, come on up. If you can just say your name and your address, please.
I'm Paul. I live at 20 Pembroke Circle, and
I'm sorry, Paul, can you say your last name?
Beaupre.
Okay, thank you.
My grandfather wrote this, but he can't be here right now, so
Okay.
he wanted me to say it for him.
Okay.
Good evening. My name is Paul Beaupre. I live at 313 Bachelor Street, Granby, with my wife of 53 years. I have lived there since 1973. I am a Vietnam veteran who suffers from the effects of Agent Orange. I have COPD, my wife has asthma, and we are concerned with the effects that this open mine could bring to us. Previously, we have submitted letters from our doctors verifying our concerns. Tonight, I want to address a comment from a previous meeting stating we already have a lot of truck traffic on Bachelor Street. I am retired and I am home a lot, working outside or walking my dogs. The street has minimal truck traffic, and the majority is delivery and service trucks. These vehicles are mostly vans, and the others are box trucks and oil and propane delivery trucks. Occasionally, there is a larger dump truck or other larger trucks. This brings me to the construction of the road that was paved approximately 5 years ago. I spoke with Mr. DeRoches of the town of DPW. He told me that the portion of the road from Harris Street down to approximately 330 Bachelor Street, the old asphalt was removed, regarded and paved with one course of 2 inches of asphalt. The remainder of the street to School Street was overlaid with asphalt rubber chip surfacing. This type of paving will not hold up to the heavy use of 10-wheel and tri-axle trucks on the surface. These trucks weigh in at 77,000 to 80,000 pounds, according to the scale operator at the Notch Quarry. The following are the trucks that are normally used on Bachelor Street: vans that weigh less than 10,000 pounds, box trucks that weigh less than 26,000 pounds, and 6-wheel oil and propane bobtail trucks that weigh in at 33,000 pounds. I was a paving contractor for 11 years. I contracted for many engineered projects for parking lots and gas station for Mobile Oil, Republic Oil, OR Coat, Adams and Ruxton, Chicopee School System, and local Pizza Huts, a number of local banks, and parking lots for Providence Hospital. These projects were all engineered and created by architects. I stopped at the Northampton State Highway Department office to discuss my calculations. I submitted a copy of Mass State Highway Department Highway Design Guidelines to the Select Board along with my letter and information. According to the Mass State Guide, the road should be paved with 2.5 inches of base or binder asphalt, then 1.5 inches of top surface. This is what is needed for heavy truck traffic. One course of 2 inches is what is done for a home driveway, and the asphalt chip overlay is one step above gravel road to get a hard surface down. The surface has already been contracted to a commercial crack fill company a year to 1.5 years ago to fill the numerous cracks to save the life of the surface, and it is only 5 years old. I am not critical of what has been done. I know there are budget restrictions and you try to get as much as you can for the money that is available. I feel the taxpayers of this town should be not be burdened with the cost of road repairs for the enrichment of a select few. This permit should not be issued. Thank you.
Thank you. Chris, do you want, did your grandfather want us to have a copy of that letter? We have that one. Okay, thank you. Yes, in the back. I'm sorry. Yeah. I don't know your name. Come on up. Hi.
Greetings, Granby Select Board.
Can you just say your name and your address, please?
Oh, Susan
Thank you.
Lambert, 308 Bachelor Street. I'm
Thank
on
you.
the corner of Tromke Avenue and Bachelor Street. We began these public hearings for the LJ Development Tromke Ave special permit on February 5th, 2024. And this will be the fourth hearing, not counting the canceled meeting and the continuance requested by Jim Tromke. Up until today, the Select Board and Granby residents have not received any studies on the community impact from gravel mining. This is a stark contrast to a similar small town of 2,000 people called Huntington, Mass., where a special permit for earth removal is also pending. The Huntington Planning Board had already requested 9 studies by the second public hearing to study the impact on its residents and is proceeding to find consultants to complete the studies before any decisions are made. We want transparency and fairness in our process, and we again urge you to protect Granby residents and natural resources. Please follow the Granby bylaws and mandate studies for the impact studies requested many times over the 4 public hearings and supported by our petition signers. Comparison to Chartier gravel pit. Jim Tromke, Granby chair of the planning board and an owner in the special permit project, has drawn many comparisons to the Chartier gravel operation and other backyard gravel pits for which no documents have been presented. From what I understand, backyard gravel pits existed before the planning board came into existence and are no longer casually allowed given their detrimental effects. First, the Chartier gravel operation began in the early 1940s, according to the last permit application submitted in 2023. Around the start of the Chartier gravel pit, the 1940 census indicated that there were about 1,000 people living in Granby compared to over 6,000 today. The two maps, which I have on the board over here, people have take time to look at it. The two maps, one from 1943 and one from 2024, show the significant expansion of houses along Bachelor Street and Tromke Ave, evolving from a rural to a more residential community. A map from 1943 indicates there were about 5 to 6 houses in the neighborhood of the Chartier gravel pit. For comparison, there was only one house on Tromke Ave at that time. In addition, Chartier's house abutted their gravel pit, and they profited directly from the operation. This contrasts with other non-Tromke abutters whose land may be as close as 25 feet to the gravel pit, and they will not profit. In fact, abutters and others in proximity may actually lose money if they decide to sell their homes. While I was door knocking and informing residents about the second special permit application, I spoke with a Tromke Ave resident who stated they had gotten a good deal on their house because of the ongoing 2011 lawsuit against the first Tromke Ave gravel pit permit. The price history of the house showed it was put on the market for $214,900 in December 2010. There were around 9 price decreases made over the house ultimately sold in December 2011 for $135,000. Please note that the house was sold before Judge Fine overturned the special permit. That is almost an $80,000 decrease in this issue, and this issue needs more study. I want to remind you about the other special permit pending in Huntington, where their planning board has asked for a study on home values around these gravel pits. I request that Granby do the same. Right-of-way and nature of Granby. Granby has always been known as an agricultural town captured by our historical society's work, and more recently, our designation as a right-to-farm community. The 2016 Planning Board, chaired by Mr. Sexton and Vice Chair Mr. Jim Tromke, commissioned a land use study by the Pioneer Valley Planning Commission that surveyed town residents on their version for the town's future regarding its preservation and development. Their responses did not include more gravel pits. In fact, an overwhelming majority valued peace and quiet and wished for Granby to continue as a small rural town with scenic vistas, working farms, and historic buildings. Town residents also value the preservation of their natural resources and the avoidance of the loss of these resources to development. This study further adds evidence to Judge Fine's assertion that this project does not meet the bylaw criteria. This is what a majority of town residents want, and we just want you to listen to us and do the right thing by the town. Lastly, I want to again assert that I do not give permission for the right-of-way on Tromke Ave to be used for industrial use for the daily hauling of gravel. In the 1990s, when Ernest Tromke sold several lots to non-Tromke families, I did not object to the building of houses or increased traffic, as the use would remain residential. In addition, the Tromkes never upgraded the road to subdivision standards as the plan indicated. I strongly object to the right-of-way on Tromke Ave for industrial use. The right-of-way established in 1931 was for Tromke Ave residents only. At that time, there was one house. LJ Development is not a resident of Tromke Ave and not even a business in Granby. I have goats with close proximity to the property line, and my grandchildren and I walk the road with our goats. Our quality of life will be reduced with the dust and diesel fuel coming up and down the road. Again, we ask that you vote no on this permit. Also, I would like to add one very important fact. There is no documentation at the town hall that these gravel pits have been monitored throughout the years. Thank you for your time.
Al?
Al Vandermark, 280 Bachelor Street. So many issues, so little time. I want to bring to your attention an issue that I don't know that it's getting the proper attention tonight. We've talked a lot about the water and runoff and studies related to the pit itself, but we're not talking about Tromke Avenue. And I recently was learned that Tromke Avenue was a private way. I had an interaction with one of the owners. I was under the impression that because the town of Granby maintains the road for snowplow purposes, that Mass General Law actually says that it can't be considered a private road. So I was walking my dog. I took some of these pictures. Let me turn this around for you. So here's some of what I learned when I was apparently trespassing, but that's not entirely clear to me. If you are on the culvert itself, as you can see from this picture, only one vehicle can be on that culvert. That means that the traffic study that we're asking about shouldn't be limited to Bachelor Street, but should include Tromke Avenue. That also means that the culvert itself, which was privately built, never inspected. It's a private road, so that a residents, it's none of their concern, according to Jim Tromke, as quoted in the Hampshire Gazette, the article that was published recently. If that road, if that culvert was not inspected, it's over a brook. What questions does that bring to mind? How do we know that was built to state standards? How do we know that that culvert will withstand the triaxle trucks loaded with gravel and sand? We can't know that. So while we've been focused this entire hearing today on the extraction site, the mining, we aren't asking about the dust and the particle, about the sound, about the civil engineering studies. We're not asking for any of those things relative to Tromke Ave. And I am asking you to expand your ask to include these. And I would also urge you to investigate the conditions under which that culvert was installed. Because if it was installed by a private individual on private property without inspections, we can't be sure. We can't be confident that the vehicles that cross that culvert won't collapse the culvert and end up in Bachelor Brook. And then we are talking about an entirely different situation.
Al, I'm just confused because we are having a civil engineer to go and do a peer review, and it does include Tromke Ave.
It includes
Because
the
that is
road and the
project.
culvert?
Yes, that's
Okay.
the project.
Very good. Thank you.
So it would have to include to the site and out of the site and whatever roads they're taking to haul that.
That is what I wanted to hear, because it wasn't several times when the attorney was speaking, he was talking about only the site, and I wanted to hear you say that it was the whole, that it included Tromke Ave.
No, it says for the project, so it's the whole project.
Thank you. So a couple other points that have been brought up tonight. Mr. Sexton, I think that it was you who asked at the 2-5 meeting, you asked why folks hadn't raised concerns about the Chartier gravel pit operation. And so I did some research on that. A few folks have already done it, so I'm not going to go into too much detail, but that pit did begin in the 1940s. And then at the 2-5, the February 5th meeting, Mr. Greg, is it Greg Orland?
Greg Orland, yeah.
Yeah. He actually said that pit had expired. It had run out, and they didn't have a whole lot left to pull out of it, which was why he supported the new Tromke Avenue pit. But the question you asked that I thought was really interesting and important, you said, why didn't people oppose the gravel pits before? And that's because the Orland pit is the only pit that we've had operational on Bachelor Street. And the permit that you signed through March of this year permitted permitted pulling just 5,000 cubic yards per year. Since the new letter was received that reduces the annual withdrawal of the Trumpke Avenue pit, that pit has been increased to 10,000. Now, there is a question about if he testified in February that it was depleted, how can they continue to draw more? I don't know that there's an answer to it. But I do think it speaks to the question that residents weren't concerned about it because it had depleted, because they weren't pulling from it. So folks weren't concerned about it. The other thing that's important is that the map at the town hall, that it's a USGS map at the town hall that lists gravel pits. You asked a really important question. You asked about property, about people seeking residence. The Bachelor Street gravel pit is not on that map. So if I were a new resident, if I were thinking about buying property here and I went and looked at this USGS map that is hanging in town hall, that pit isn't even there. People wouldn't know, so they can't make an informed decision. And so I think that's another important point. I do not envy you the decision that you have to make. But the permit says, the bylaws say that it shouldn't be a detriment to the community and it shouldn't harm residents. And one of the things that we have shown is that we have packed these meetings time and time again. Even when the meetings have been canceled or rescheduled at the last minute, there is significant concern in this community about this operation. And I really appreciate the attention to detail that you are showing tonight. And I look forward to hearing the results of the surveys that you and reports that you've asked for so far. There's one more point I want to make, and that is Mass General Law actually has a lower threshold for decibels than Granby bylaws. So just be aware of that as you're looking. Our bylaws may be outdated in that aspect. I know Massachusetts updates things a little more regularly, but Mass Gen Law decibels is lower than our Granby bylaws. Thank you for your time.
Thank you.
Thank you.
All right, gentleman in the red, come on up.
Hi,
Hi.
I'm Bill Shantz, and we live at 350 Bachelor Street. And I guess I've kind of gotten a reputation after the first meeting of being the frog man. And but in this case, I'm more concerned also about all of these things, but primarily the noise study as it is. Being a musician, I know that noise on a flat street is not the same as noise going up a hill or back down the hill. And I'm curious how this sound study is going to be conducted, going up Harris Street, for example, or going past our house where there is a slight uphill, the trucks gun to get up the hill, and then they take off their air brakes to go back down the hill. It's very noisy when these dump trucks go by. There aren't that many now, but that will change. And I came here because of the quiet and the peace and the great road and the great neighborhood. And if all of that starts to deteriorate, I don't know. It really would be a tragedy for me, being very sensitive to sound and the other pollutions as well. In addition, I know I've heard all night about all this legalese. I'm not a lawyer. I don't know these things. I don't know where the bylaws came from. But I would suggest that at the moment that the bylaws become more important than the will of the people, maybe the bylaws have to change. Because it's clear that people don't want this. And I think that it should be considered very, very seriously to make it not happen. And that's what I have to say. Thank you.
Thank you.
Thank you.
There was a gentleman that was standing up in the back. Do you still want to speak? Yeah. Oh, you're all set? Yes. Yeah, blue shirt. Sorry.
Hello, my name is Devin Gerstenfield. These are not my words. These are words written by a neighbor who couldn't attend today. Dear fellow residents of Granby, we write as longtime residents of Granby to voice our opposition to the proposed gravel pit project on Tromke Avenue. We are unable to attend the meeting on June the 3rd, but we hope our views will be taken into account. We authorize anyone to read this letter to the meeting. When we moved into our house on Ferry Hill Road in May of 1996, we got a very unpleasant surprise. Huge dump trucks from the Orland Company were using the road on a daily basis, roaring by our house, which is only a few feet from traffic. The noise was truly horrendous. It sounded like trucks were rumbling right through our house, and in fact, there were times where we could actually feel the walls shaking and hear the windows rattling. Often this would go on all day long. Any activity that required concentration and focus, reading, writing, computer work, even television watching were nearly impossible. The trucks would literally drown out your own thoughts. It is no exaggeration to say that the constant disturbance, which exceeded by a wide margin the level of mere annoyance, had a significant impact on our quality of life. This was surely true for our neighbors, both here on our road and on all the other residential roads where the trucks passed as well. When this problem went away, life got much better, and happily that was some time ago. But the memory is still vivid and puts us in very strong opposition to any project that Granby might take that comes even close to reproducing that problem. Whether the Tromke trucks are routed in front of our house or not, no one in Granby should have to tolerate that kind of disturbance. Our roads are too narrow and too residential. There are too many senior citizens and children in our neighborhoods, and they surely shouldn't be subjected to this kind of skull-jarring noise and vibration. It's just not in keeping with the profile of a beautiful, quiet little town like Granby, where people cherish their peace and quiet, some of whom moved here largely for that reason. Please do not permit this project. Sincerely, Christopher L. Miller, Christopher Rivers, living on 64 Ferry Hill Road.
Thank you. Yep, in the back with your hand up, you can come up.
It's been some time. Hi, my name is Melissa Harder. I live at 326 Bachelor Street, and I'm reading this letter from a neighbor who was unable to attend. To the members of the Select Board, I am writing with regard to the application by LJ Development LLC for an earth removal gravel pit on Tromke Avenue off Bachelor Street. I am one of many Granby residents strongly opposed to this endeavor for a multitude of reasons. I am aware of a similar application in 2010 that was also opposed, and I see no reason that the same project should be approved now. My late husband and I were truly thrilled in 1990 when we were able to buy a beautiful piece of property on Harris Street from Les and Pat Reynolds. It had everything we were looking for: natural beauty, adjacency to the Holyoke Range and its hiking trails, peace and quiet, good neighbors, and all the setting of a lovely New England community of Granby. We built our dream house using a builder from Granby, and over the last 34 years have loved being here and tending to our gardens while enjoying the view of the verdant hills around us. Recently, I became aware of the plan to activate a large and invasive gravel pit a few miles away. A hydrogeologist acquaintance from the area terms these projects strip mines, the subject of graduate studies. There are already many gravel pits in Granby, too many in my view, and this project will have a negative impact not only on the neighbors in the Chomke Avenue area, but also on all residents across the town of Granby. We must take it upon ourselves to protect the beauty and health of our land and not allow it to suffer inappropriate industrious incursions. I have read the responses of LJ Corporation's attorney, Mr.
Bertholomew.
I'm sorry.
I think it's Bertholomew.
Sorry, Bertholomew. And many of them do not fulfill the requirements that a special permit must ensure a harmonious relationship between proposed development and its surroundings, to quote from the bylaws. Just a little bit more. As I see it, some of the key issues include the inappropriateness of the industrial project in a residential neighborhood where it will certainly have a negative effect on the health and quality of life by nearby residents. The obvious degradation of the fragile environment that will be caused by the terms of air, water, and land itself. Issues of noise, traffic, and the potential for pollution from runoffs and spills. The ruination of Bachelor Street, surrounding roads, and land that has been recognized for the scenic qualities for which Granby is known. The current condition of Chomke Avenue is in no way appropriate for this level of truck traffic, and the area over the culvert is a narrow single-lane road with a warning sign posted next to it. The danger to children, pedestrians, cyclists, and cars on Bachelor Street and other streets nearby. The potential for the expansion of future of the truck routes to other streets in Granby, such as the other end of Bachelor Street, Harris Street, North Street, and so forth. An 8-year project will certainly involve some expansion. I think she wrote this before we knew that it was a 30-year project. The responses of the applicant's attorney to a number of issues at hand do not appear to be accurate. Here are some of them. This neighborhood is hardly a suitable location for the project. The idea that it will increase air, water, and noise pollution cannot be true. That it will not increase air, water, and noise pollution cannot be true. There is no way to use large trucks in addition to earth-moving equipment, bulldozers, earth movers, screening equipment without noise, dust, and vibration. The comparison of a gravel pit operation to the building of a single-family home is simply ludicrous. The opinions of the Board of Health and Granby Police Department appear to have been ignored, even though they were strongly worded. The anticipated truck traffic on Bachelor Street and eventually other streets will surely cause damage for which the town will eventually be financially responsible. The temporary sanitation facility mentioned that will no doubt be needed on the site has evidently not been proposed to members of the Health Board. The proposal to loan and seed over the areas for which the material has been removed will surely not enable the area to grow back to its natural state. This residential neighborhood surrounding Bachelor Brook is not the kind of place in which to allow this sort of industrial project. Other neighborhoods in Granby have already suffered the consequences of other gravel pits, water issues, property values, and I feel that we should learn from those negative experiences. It is 2024 now, and although these were approved in the past, there is no reason to continue in this way. It is clear from what we see around us that the environmental deterioration has become a major global problem. Let's start to address some of this by looking right here in our own beautiful town and stop the continued destruction of projects like this and their efforts and their effects on the people and the natural world around us. I would like to thank the Select Board. I would like to think that the Select Board has a well-being of its people, lands, and highest priority, and that every proposal they approve will reflect that. Wendy M. Watson, she lives on Harris. So
Thank you.
thank you very much.
Thank you. I just want to, I know she's not here for that letter, but the Select Board is not ignoring anything. We are looking at everything. So I just want to clarify that. We're not ignoring any letter or any documentation that we have. We're taking everything into consideration. So, and as far as sanitation, there was no sanitation at the site. Okay, I just want to make sure with the engineer, Frederick. No sanitation at the site.
Temporary.
A Sandy can, okay. Because I thought it was only going to be a Sandy can, so I just want to make sure there's nothing else. Okay. Okay. All right. Yes, come on up. And then we will.
My name is Dan Gerstenfeld. I live at 326 Bachelor Street, along with my wife and my son, who just spoke to you guys. One of the big concerns, actually, I have two concerns. One is my well, and so it's a shallow well, of course. And one of the concerns that I have is the hydrology study that was mentioned. Does that concern the water, our wells, and the effects of removing so much gravel? Because I think that it may have an effect on the aquifers underneath, and how many houses would be affected by that? And then what would be the remuneration for us in case the water is affected? My water is almost crystal clear. I don't need a filter for it at this point. I mean, it's great water. The second thing is kind of looking at this right here. This is just me walking my dog along the street, along Bachelor Street. And the interesting thing about this is I'm on one side and the trucks are giving me 4 feet of berth. They're already in the opposite lane. This is a winding, narrow serpentine road probably in the same direction in which the trucks would go out towards School Street. And the concern that I have is if you have someone that's walking along, or you have a child out there, or you have an elderly walking along, or myself with my dog, which, is very important to me. Don't want to do anything to the dog. But the concern that I have is there's no room. What happens if there's a truck around one of these blind corners? There's no way to get out of the way. What happens if there is someone walking along the side of the road? There are no sidewalks. There's really, in some places, there's no place to go, especially over one of those bridges. And so someone's, the chances of a really bad accident is significant. And so those are just some of a couple of my concerns, along with all the other ones. And then I'm not sure that it's keeping with the character of our community at all. And I think that's a violation of some of these rules that we have in place. And those are things that I wish you to look at. Thank you very much.
Thank you. All right, so we've heard from everybody. Looking at what we need, I guess I just want to be clear on what the select board is asking for, because we're all in agreement. So we are asking for a particulate matter in the air mitigation study. We're asking for the title search. We're asking for a traffic analysis to be done. And we are asking for a civil engineer to come in and peer review the project, which will look at the culverts, as well as whether or not a hydrologic study will need to be done, because the civil engineer will address these issues when he's reviewing the plan. And then for peer review, right now we have the ideology study, which we're going to hold on the peer review until we get the rest of the studies. So is the select board in agreement? Did I miss anything?
Not that I see, according to my notes.
Because the civil engineer will also peer review what we already have. So that's going to wait until after we have the particulate matter mitigation study, the title search, and the traffic analysis. So that's what we're going to be waiting for. The applicant, how much time would you need to do those studies?
Attorney Berthium sends his apologies. He did have a prior commitment that he had to leave at 8 o'clock for. We discussed it before he left, and we would like to ask for a 60-day continuance.
That's actually what we had in mind, I think, was 60 days. I think when we 45 to 60 days, but 60 days.
60 days seems fair.
Okay.
Just to further clarify, so what we would anticipate doing in 60 days is the board would reconvene.
Yep.
You'd be reconvening, hopefully having received maybe a week or two in advance, if possible,
Okay.
copies of these additional studies. So we're talking about an air pollution, or you've called it a particulate matter study.
Yep.
We're talking about a traffic assessment, and we're talking about the title report, which it sounds like is something Attorney Berthium can provide sooner than later.
Yep.
None of that will have been peer reviewed yet, and so at the
Right.
next session of the public hearing, you'll simply be discussing what you received, asking any initial questions you may have, receiving any further feedback from the public on those studies. But I guess I would advise you not to get too deep into them, because none of us are experts in those matters. And so what we'll be doing at the next meeting is discussing with the applicant through council what sum of money might be necessary. So what you may want to do in the interim is you may want to start reaching out through your staff to potential peer review consultants. You don't have a report to give them yet. You really can't get a defined scope of services, but you can at least find out who's available and that they would be able to review the sorts of studies and reports that you're anticipating receiving. So that when you have that meeting in 60 days, you get authorization, you get a commitment from the applicant to have those peer reviewed. We're not starting the next day cold calling potential consultants and losing 2 or 3 additional weeks thereafter.
Now, they would be giving us a conditional quote, right? Because they don't have the analysis or in front of them or the study in front of them to say definitively how much it would be to do that peer review.
And I'm not even suggesting that they'd be willing to give you a quote, but
Okay.
you could have conversations with them. You can contact a couple of engineering firms and say,
Okay.
we have plans for an earth removal operation. Is this something you have experience reviewing? Would you be able to do that for us and provide us a quote once we know what we're receiving from the applicant? I guess with the engineering, you could actually give them the plans because we know what we've got already.
Right.
Same with the noise. With respect to the other topics, we don't know what we're receiving yet, so you'll just have to have more generic conversations with those potential consultants about their availability to perform the work and to do it on a reasonable timetable.
May I ask,
Yes.
being at 60 days, and I don't know how long some of these studies take because we don't do them. But let's say we had things done in 30 days, submitted them to the board. Can the board then seek peer review quotes, maybe get them before the 60 days, not necessarily have them done in the next 60-day time, but have the quotes?
Certainly, you can seek information. You can't proceed with the peer review because we won't have the funding yet. We won't have
Right.
the authorization, the approval of the quotes. But if you do get those studies sooner, and again, you've already got the noise report, you've already got the civil engineering plan, so we should be able to within 60 days get fairly accurate quotes or estimates for that work. For the others, if we get them sooner than anticipated, certainly you can send those off to potential consultants and get clearer quotes as to what they would charge to complete a peer review.
Thank you.
Madam Chair, we heard of one issue regarding the situation. I believe one other council said that they would have to do a survey to move the road away from where it is right now.
Well, I think that was going to be in the title search though. So he's going to do that first.
I believe what he essentially said today was that we were right. They're gonna have to move the road, and they need a survey to move the road. And it may be that moving the road is gonna put them into wetlands areas to move the road. So at some point, they're gonna need that survey. I don't know if you tell them to do the survey now or wait till later, but I believe Brother Council has essentially said he didn't give you the title search because we were right. They can't keep doing this with industrial uses.
I also believe that Attorney Costas said that if we provide a survey, that the condition of approval, if you wanted to go that way, would be
Right.
to move the road before operations started.
Do we know if they even have the space? You might want to see the survey.
Would you recommend a survey for that?
So Madam Chair, I think we can do this in more of a piecemeal fashion. I'm not going to
Okay.
opine on whether a survey is needed or not yet because I simply haven't seen the title search and I haven't seen
Okay.
the plans indicating where the roadway or driveway is today and where it may potentially need to be moved to. So I suggest we do it in a more piecemeal fashion. Let's await the title report. I'll review that report. Hopefully, if I get it within the next 2 or 3 weeks, I can review it well in advance of your next meeting and be prepared to provide some further advice at that time. If there is a concession, and Attorney Berthium's not here now, so I appreciate the characterization of what he said. I'm not saying the characterization is wrong, but he's not here to defend himself. So if he concedes that in fact the roadway is in the wrong location and needs to be relocated, that does potentially open a can of worms if relocating the roadway is going to create problems from a construction standpoint in terms of where it's done and what environmental or site work, what environmental harm or site work might be required. But that's, I think, a discussion for another day. We should do this in steps.
Okay. Thank you. All right. So we're in agreement with everything that the select board is asking for in order to make sure that we are looking at all criteria, the 11 criteria. And I think there was one person with the hand up. You'll have to come up here. I'm sorry.
Giselle Livingston, 99 Bachelor Street. I just have a question on the audiology report. Do you know, is that going to take place the whole length of Bachelor Street? Or is it just going to be within certain feet of the?
So the audiology report was the one that was given to us today, and I haven't had a chance to read the whole thing in depth because I've been at the meeting. So it's, as one resident said, she claimed that it wasn't comprehensive. And again, I haven't had a chance to look at it. So we would have a peer review look at that and decide if more data is needed from there.
Okay, because a gentleman made the point that he lives on a hill and the trucks go up, and so I didn't know. I mean, it's very hilly and curving, and I didn't know if they were going to do it from one link to the other, or if it was just going to be at the site.
I think that would be a question for the person who peer reviews it.
Okay, thank you.
Yes, thank you. All right, Rich, do you have anything new to say, Rich? Okay. Yes. Mike, sorry, so that they can hear you at home.
Rich Stomaraki, Bachelor Street. If they move the road, they have to comply with the subdivision standards, don't they? It has to be paved.
That is something that our civil engineer is going to look into. So I'm not an expert.
Yeah, but
So that's
I mean,
something
just
that
putting
he
in
has to
another
look
dirt
into.
road doesn't do it. It
Well,
has to
they're
be-
talking about the right of way. That's what moving the road is for the
I
right
know,
of way off.
but
Key.
if they want to anticipate driving the trucks over the road, which is future development, they have to bring it up to subdivision standards. There's no question about that.
Okay,
I just want to bring that point out.
thank you. All right. Yep.
And just related to noise, I know that the road is dangerous and probably good. I know that the road is hilly, and we're talking about trucks that are probably laden down with 70,000 plus pounds. Will there be something considered in regards to noise when you do the study about J brakes? Because those are incredibly loud and incredibly disruptive.
Is the J brakes the same as the air brakes, or
No,
a different brake?
It's a little
Okay.
bit different. It's basically using the engine to slow the vehicle down.
Okay.
That's something we have to look at. It's not a town ordinance or part of the bylaws, so I don't know if we can actually insert that. That's something, because we have our.
But it's, it's part of the noise study too.
I understand that, but as I said, currently it's not part of our, part of our
Right. But
ordinance and stuff like that. So we can't just.
No,
But those are things we're talking about, and so most people do understand that. That's why we're having experts be involved, a peer review, to look at all these things, because these are what they do for a living. These are the experts, and they're going to look at the information that's being provided, and then bring back information to the select board to help us make a decision.
Right. And
So
what I'm saying is, if you can have that be included in something that they would consider that we're looking at decibel ratings of the whole operation for the removal of gravel in this mining operation. Thank you.
Thank you. All right.
Make one more comment on that part of it.
Sure.
And Brian DeShay, 312 Bachelor. The bylaws here, you have a noise bylaw that says 65 decibels during the course of the day. We also have one on your special permit that talks about nuisance, which is a huge difference compared to just decibel levels. I have given you tons of research and articles about the effects of noise. We're not talking about 65 decibels. We're talking about 50 decibel. I'm talking to you at least 75 to 80 decibels right now. But we're not considering this a nuisance. Remember what a nuisance is when we're talking about all these different facts here and all these different exposures that we're going to have. And the health effects that are documented and what I've given you. So thank you.
Thank you.
Oh, and yes, the Massachusetts law is 10 decibels above ambient noise. There's no reference on what was just given to us about any ambient noise here. And that really plays into what nuisance and health effects will be. Okay, so when we're talking about Boston, their decibel level is 70 decibels. So their level of what is considered a nuisance goes up. When we're here in little old Granby with no other, that brings us down to a much lower level.
Thank you. All right, so 60 days. So now we have to look at a date moving forward. And I know the applicant's attorney had to leave
December 5th.
December 5th.
60 days out brings us right around Thanksgiving. So the following week would bring us into December.
Okay.
I think December 5th is a Thursday, I think, if I saw it
Yep,
correctly.
it's a Thursday.
What? We could recommend is, I know the applicant's attorney's not here, and I'm assuming that you want him present at our next meeting, so we could do what we've done before. We can continue this to our next regular scheduled meeting, but the only purpose would that be is to reschedule it to another date, so we can confirm that the applicant's attorney is available, because after we schedule it to December 5th, that would be the day that it's gonna happen.
Sounds like a good idea.
So our next scheduled select board meeting is October 7th.
And we have time for the
So we would open it up at 5:31, right, Chris? Because we're just going to be setting a date for the continuance to December. Conditional.
Only to set
A
a
date.
future date.
Okay.
No discussion.
And that would be for, again, the future date that you're
meeting
gonna,
is December 5th. But
for the attorney. Okay.
thank you.
That's what we're looking at. We're not setting it, but it's
Right.
Yes.
in consideration. If it works, and it works for Attorney Acosta, if it works for that, then that will be a date we would consider.
Yep.
Thank you.
Would
Thank
the
you.
board like me to send an email to Attorney Rapine?
Yes. And the applicant will check with them too. But that way it's in writing.
It's confirmed.
Yeah. Please.
Okay.
So with that, I will entertain a motion to continue the hearing till October 7th,
5:30,
5:31,
5:31, October 2nd.
I will make a motion.
to set a date,
And
here to set a date.
I will make a motion to continue the hearing until October 7th at 5:31 at 10B West State Street, where we will then choose a future date for the next gravel pit meeting.
I'll second the motion.
And only for discussion.
All for discussion. Agreed.
All right. Any further discussion after that?
No.
All in favor?
Aye.
Aye. All right. And now I will take a motion to adjourn. No, never mind.
Make a motion.
No. We already continued it, so we're good.
We continue. Good.
Yeah, we're good. Thank you.
Sound like a meeting.
Yeah, it's not a regular meeting, so we don't have to, yeah.